Joining me now, Mr. Tom Maliti. Thank you very much for joining us in studio. He is from the International Justice Monitor, and he's joining us now just to give us a breakdown on the implications of the case facing Deputy President William Ruto and that landmark ruling that is expected to be given this evening by the International Criminal Court. But let's begin with what the International Justice Monitor is and what it does.
Thank you for having me. The International Justice Monitor is a web portal that is focused on international justice. You'll find a wide-ranging reports on international cases at the International Criminal Court, in other jurisdictions, both national and extranational, as it were. And my particular role is I report and analyze the Kenya cases at the International Criminal Court.
Now, you've been keeping a close eye on this particular case following Deputy President William Ruto on the use of Rule 68 of recanted evidence. But just take us back a bit to why the prosecution wants the recanted evidence kept in the court's records, and why the defense of Deputy President William Ruto wants the recanted evidence thrown out.
I'll answer that question, but I'll also just refer a bit to the Lubanga case that you referred to earlier on, and say that the Rule 68 at that time, when the Lubanga case was ongoing, was different from the Rule 68 that is being applied in the Kenya case. And the main difference is that in the Kenya case, there was an amendment that was introduced in 2013 that allowed statements of witnesses to be used as evidence in case there is evidence that those witnesses have been interfered with. Whereas in the Lubanga case, the reason why the statements of those witnesses were admitted as evidence is because I think one of the witnesses had died, which was one of the provisions in the old Rule 68 and as well as the current one. And possibly one of the witnesses had said, well, either they were too old or sickly to testify, so they accepted, which is one of the requirements, they accepted that their statement be used as evidence in lieu of them testifying in court.
So back then there was no allegations of the evidence being corrupted?
No, that provision was introduced in 2013. So and that's the main provision that the prosecution is relying on to argue that of the 5 witnesses, 4 of them, the prosecution alleges, were interfered with. The prosecution presented evidence and said this is how they were interfered with. And on that basis, because these 4 witnesses eventually did testify in court but recanted the evidence, the prosecution argues they recanted the evidence because they interfered with. They didn't recant the evidence because the witnesses had a change of mind and felt that what they had told prosecution investigators in 2010, 2012, whenever it was they spoke to prosecution investigators, was not true, and therefore they should now tell the truth in court.
Right. So what does Deputy President William Ruto's defense team have to say about this?
The defense teams of both Deputy President William Ruto and former journalist Arab Sang, we normally forget that Josh Arab Sang is an accused person together with Ruto in this case. Both their defense teams have said that the court has misapplied Rule 68. They say that because the rule was changed in November 2013 and the trial of their clients began in September 2013, the chamber cannot retroactively apply the rule. That's their principal argument, and they say that there are provisions within the Rome Statute of the International Criminal Court that guard against that. And secondly, they say that even if one was to say that Rule 68 applies, the prosecution has not proved beyond reasonable doubt that these witnesses were interfered with. Therefore, again, on that basis, these statements should not be admitted as evidence.
Right, so that's the current situation. But the ICC is set to give that landmark ruling tonight. So let's talk about either or of the outcomes. If the court decides to uphold this appeal against the use of recanted evidence, then what is the implication on the case?
The implication is that the statements will be evidence. And then, depending on how the case goes, at some point the judges may be required to weigh that evidence against other evidence and see whether it is of value to the case or not, and of what value exactly it is. But I guess because we have been paying attention a lot to the Ruto and Sang trial for some time, the immediate implication is that it will present a challenge to the defense in the no case to answer motions that they filed before the court.
Right. Now, having kept a close eye on the proceedings at the ICC and other cases that they have dealt with, what do you think the outcome will be?
It's difficult to say because the defense have filed 7 grounds of appeal. So the appeals chamber will have to look at each grounds of appeal, analyze it, and make a decision based on the law. I think the important thing to note here is that the appeals chamber is not going to be making a decision based to determine whether these statements are genuine, whether these statements are sound evidence or anything like that. The appeals chamber in previous rulings has been clear that this is the work of the trial chamber. Our job is not to weigh the evidence and determine whether the evidence is good or bad. But they're very clear and categorical that their role is to interpret the law. So primarily the appeals chamber will be looking at whether the grounds for appeal in terms of the law should be upheld or not. That will be their primary focus.
Right.
But obviously, at the back of their minds, they will be aware of the background of the Ruto and Sang trial, where there have been serious allegations of witness interference, which has raised questions about the integrity of the court process at the International Criminal Court. And this is one of the rare instances where the appeals chamber will be weighing in on that. So for instance, the Ruto and Sang defense have said the standard of proof is not clear, and we believe it should be beyond reasonable doubt. The appeals chamber may say, actually the standard of proof should be this, and now you trial chamber, based on our clarification of what the standard of proof is, look at those witness statements again, look at the circumstances around the witnesses in terms of interference and so on, and determine whether those statements can still be admitted as evidence.
Right. Now, as you mentioned before, the prosecutor Fatou Bensouda brought evidence to show how these witnesses had been corrupted, but the defense team representing Ruto and Sang say that the prosecution is only doing this because they don't have enough evidence, so they're bringing up false evidence in their case. So in your view, the evidence provided by Fatou Bensouda, was it credible that the witnesses had indeed been corrupted?
There's no way of assessing that, and for a very simple reason. One of the conditions under which these witnesses testified in court was if they gave evidence of how they were approached to be bribed, how they were intimidated, and so on. And they were allowed to, the condition was that whatever provisions under the Rome Statute could be used against them, because it's an offense to both give a bribe to a witness and receive a bribe as a witness. Whatever provisions in the Rome Statute that could be used against them will not be applied in that case, and therefore they should testify freely on those circumstances. Now, that entire testimony was in closed court, was not open to the public, so there's no way of knowing what exactly that evidence is, its strength or weakness, and even the documentation around those allegations which the prosecution presented in court and which have been disclosed to the defense are not available to the public. So the best one can do is say, the prosecution obviously will argue that yes, witnesses have been interfered with and we have evidence, and the defense will of course say the evidence you have is not worth the paper it's written on, and in fact these witnesses, the reason why they're recanting is because they have been struck by a conscience of guilt and realize that, look, we told lies, and we told lies because we were promised, to be relocated and be paid handsome monthly allowances and that sort of thing, and we've realized that's not the case.
There's also the issue of fear, because we've seen several witnesses lose their lives in mysterious circumstances, cases that have been looked into, but we haven't seen the reports of these investigations. But even as this happens, and this is a final question, Kenya is still pushing for a mass withdrawal out of the ICC. Do you think this will materialize?
I don't think so, for the very simple reason that the 34 members of the ICC who are African states have different interests. They're pursuing different interests at the International Criminal Court. The only thing that the African leadership or African leaders at the African Union are clear about is we do not want a serving president or a serving deputy president to face charges before the International Criminal Court during their tenure. After their tenure, if the ICC is so wishes, it can pursue those charges. Beyond that, you see different interests come into play. For instance, there's a suggestion that South Africa is going to pull out of the ICC. However, South Africa also wants to be the first African country to be a member of the permanent member of the Security Council of the United Nations.
Okay.
Now, they will weigh their interests at the ICC against their interests in pursuing the agenda of the Security Council and decide which one matters more to them.
Right. All right. Well, thank you very much, Tom Maliti there of the International Justice Monitor, joining us just to give us a breakdown on that landmark ruling that will be given tonight by the International Criminal Court.